What's it like now? Is it
No,
doing it?
can you just continue talking? Just so
Can I continue talking? Yes. When did the race course cease its intervening, Mr. Callis?
I think it was shortly before COVID.
Right.
I can't remember the exact date, but yeah, I don't think I've had any for a number of years now.
I'm not an horse racing fan, but I recall watching Telstra on TV many years ago. So it must have. It's not often you get a race course of that nature that's since its operation.
Yeah.
Volume is on.
Yeah,
It's working now.
Before we hear Mr. Callis' tip.
That was just for those who's now watching online. The reason I brought having a chat there was just to fill in some time, just to ensure that people can hear whether the microphones are working or not. But the discussions were nothing of relevance whatsoever to this inquiry. We've done the opening, my opening in terms of the not just informed bit of the inquiry. The important parts in relation to the inquiry, I think I'm just going to repeat, are the fact that we've received overnight 3 inquiry documents. Inquiry document 10 is a technical note by Rich in response to his legal comments. Therefore, if there are representatives of the Angling Club who are observing online today, then those comments are available or will be available shortly on the inquiry website, and they are recorded as document ID 10. So that's a technical response to the matters that were raised on Tuesday morning by the Angling Club, and in particular, the fish legal comments. So the response to those. ID 11 is a statement of common ground between the Council, Davidson and Bloors regarding the Northampton West Sustainable Urban Extension. I'm going to ask Mr. Wood in a moment just to explain that document, and in particular its status regarding signatories. And the third piece of information, which I've recorded in ID 12, is an email from Mr. Wood dated the 30th of October 2025, explaining the correlation between the 2025 HLS figures and the JCS policy S3. So those are 3 documents. We won't want to have a little bit of this. We still need to have a chat before we leave the room today regarding the section 106, the planning conditions, and I'll set some parameter timeframes on submissions of those, which I'll follow up on Friday with an email. We're going to finish up saying that again as we go through the afternoon or at the end of this morning's session. So those are 3 documents that I've received. As far as I'm aware, those are 3 documents that were left hanging from yesterday, notwithstanding the section 106.
With track changes, those track changes were made by Davidson, to the point I was making yesterday. One was that they increased the numbers over the draft that we sent to them, and secondly, that they brought first completions a year forward. So we were participating in completions in 2026, 2027. This is table 3. So when you see the track changes in red, we put a 0. Davidson's have put in a 25. In 2027, 28, we put 25, they've increased that to 50. So overall, so if you look at the column that's shaded in there, totaling 5 years, it's increased from our draft 150 to Davidson's 200. So those track changes, so we accepted and put into the final version, which was the published version. But the reason we had an interest in this yesterday was that those increases were at the behest of Davidson's. And you'll see if you scroll down, so because Mr. Tyler was interested in who signed off, the same as a common ground from the developers, and you'll see there that it was signed off by senior planning manager at Davidson's.
So the sound pattern is gone again. Live stream.
The sound's gone again on the live stream. What's your singing voice like, Mr. Wood?
I'm sorry, sir?
What's your singing voice like?
Terrible. Don't go there.
I'm back now.
We're back.
We're back.
Right.
So there is another document Mr. White alluded to earlier that is still outstanding from yesterday, which is a list of statements of common ground with the challenge sites. Dates of those. So we are working on that. So you asked for it by lunchtime today, and it will be with you by lunchtime today, the very latest.
So just, I don't know when the sound went, but there was a discussion about who signed the document that's referred to now as ID 11. And I think you mentioned, Mr. Wood, that it was Melissa Bulk, senior planning manager.
Davidson, so yes.
And there's no signature to the laws, but I think the changes, I understand, were made by Davidson's. Well, that's correct, is it?
That's correct, sir. So the date's on there, the person who signed it on behalf of Davidson's on there. And importantly, this is just for Davidson's, it's not laws that didn't respond to us. So hence the note, if you go right back to the title block, so in bold at the top there, approximately a third of the way down the page, there's a note. So this statement has been agreed with Davidson's in relation to their part of the title. So we're just clarifying that it is, in terms of statements of common ground, it's just between ourselves and Davidson's. It doesn't include laws as a signatory.
Is there anything you want to say on that?
Yes, I do, sir. I want to reserve my position, but as Mr. Tyler said yesterday, the date is important, the 14th of May, so I'd ask you to know the following 4 points, and I have this from this all who signed this. The first is there has been a material delay since the statement of common ground was signed, and that comprises the following 3 matters. The first is there was a deferral at committee. Not those matters that were before the committee were deferred. Point 1. Point 2, there's been a delay in section 106. And point 3, they're still waiting, Davidson's are still waiting for a footwork half diversion order to be approved. So that all leads to you taking that into account in the context of what was signed on the 15th of May. You say dates and say far more importantly than that matters have changed since that statement of common ground was signed. And I think most of the points I've just articulated, if not all, were mentioned by Mr. Tyler yesterday. But can I, obviously this came through no criticism of Mr. Wood at all, but I'm just going to confirm in the morning break whether there's anything additional that David wishes to say, but I think that encapsulates our position on this, that side. And I also note the fact that the word in relation to the wider document and the statement of common ground signatories, I know what it says at lunchtime. Obviously, there's a slight issue that document will be only seen by us at lunch. Can I just reserve it if Mr. Tyler has any comment on it? And he has right tomorrow morning to comment on it.
I think that's something fair for that. That applies to us as well, probably as well. And that's the council document. That the council's planning witness is not prepared in that document. It is prepared by the council, so the council's planning witness won't have seen that document either. So it's probably fair to why it the council.
Of course.
So you may not wish to comment because it's come from the council. We need to give you that opportunity to the council. Right, then the only other thing is the section 106, which is still in progression. I think the only thing I need to say is that I probably need a track change copy of.
Yes.
And what I'll probably say, the lunchtime today, is that next week if we have to track changes by the end of it and the revised conditions, and then we'll leave the week after that for completion of that agreement.
Can I just? We just put some hard dates, so I said, and can I take instructions on this? But basically, you would like the track change version of 106 by Friday, the 7th of November.
Yep.
And the final list of conditions and the signed 106 by the 14th of November.
I can look it up. Yeah.
Could I just take instructions on that? I'm sure,
Yeah.
but I'll come back before we leave today. I will just confirm whether that's fine.
It's not crucial. I can give you another week. It's in my program. I'm not going to start waiting for that. It's got things to do. So it's not crucial. So, but also I don't want to throw it straight.
I think the winter order obviously I'm sure that that's all they're aware. Thank you, sir.
I think we're up to speed at that point. I'll just have another sense check at lunchtime before we leave this room. Then we're up to speed. Right. Back to the point we put today. We mentioned earlier this morning is dedicated entirely to the evidence of the appellant's planning witness, Ms. Butterfield. I don't think there's anything more I need to say than Mr. White to introduce Ms. Butterfield to the inquiry.
Yes, sir. And can I say I'm likely to be heavily influenced. As you can see, you look out on the sea of public interest that everyone here is associated with one of the parties. So I'm not with one of the things I least like in examination chief is reading out summaries. So your leave, I know you've clearly read it. Can I take the evidence as read, and I'm just going to ask additional points in the light of Mr. Callis's evidence. What I will formally do, can I introduce Ms. Butterfield to the inquiry, and for these purposes, can we go to section 1 of your evidence, please? And I introduce you. You are a member of the RTPI and you have been since 2005. Is that correct?
It is.
And in terms of your professional qualifications, you've got a Bachelor of Science degree in City Regional Planning awarded by Cardiff University.
Yes.
You are now a director at the Birmingham office of Pegasus Group, and you have 20 years experience. During that time, you've acted as an expert witness at various appeals that you set out. You've also appeared at various EIPs. In this matter, you were instructed by the joint applicants in 2020 to assist in the preparation and submission of the planning application, which then led to Pegasus submitting the application in April 21. Is that correct?
Yeah, just to clarify, Pegasus were instructed in 2020 and I came on board in 2021 as the application was submitted.
Perfect. And you've retained your instruction in the intervening period between April 21 and now October 25.
Yes.
You're familiar with the site. I mean, broadly, how many times have you visited the site in your instruction?
3, I believe.
Thank you. And you confirmed to the inquiry that the opinions you give are subject to the requirements of your professional institution, the RTPI, and you confirm your opinions expressed for your true and professional opinions.
Yes.
Right. Next point then. Can we do an audit of where we are, please? And you've now heard the evidence, Mr. Callis. And obviously we have what we have, which is agreed, and what we have that's disagreed is quite clear. And I just, in the light of the evidence, can you confirm, is it your judgment that planning permission should be granted or refused based on the application of the tilted balance, please?
Yes, it should be granted on the application of the tilted balance.
And if the inspector will come on to look at what road he should take in the light of NPPF 11, but if the inspector is minded to apply the flat balance as a result of his consideration of the evidence, is it your planning judgment that planning permission should be granted or refused?
Granted.
Now, let's then please get into the details about the obviously the fundamental dispute that now remains between the parties is whether this is a case which effectively activates the tilted balance or not. And obviously our starting point for consideration of these matters is NPPF paragraph 11. But before we take that up, I just want to deal with a few mechanics. Can we just deal with, first of all, please, I asked Mr. Callis various questions on the suitability of the site, and I just want your confirmation. We can do this reasonably quickly. I put various propositions to him about the suitability of the site, its location, the facilities in Brackley, and where Brackley sat in the hierarchy. I just want to give you an opportunity. Is there any material matter that you disagree with Mr. Callis on those matters that you want to bring to the inspector's attention?
No, I agree with Mr. Callis on the matters that you raised.
Thank you. So the next point before we get to the tilted balance, this application or not, is just let's deal with the development plan. Again, I think it's common ground what is the development plan. I think also common ground is the statement of common ground. You and Mr. Callis clearly addressed what policies were relevant for the inspector's consideration. They're set out in the statement of common ground.
Yeah.
You also broadly agree, I think, on what are the most important policies, but overall, applying your section 38(6) judgment, starting point, can you tell the inquiry, is it your judgment this is a development that complies or does not comply with the development plan, please?
So my judgment is that there is conflict with the development plan on the basis of locational policies, some landscape conflict, and also some slight conflict in terms of noise based on construction.
Now, obviously, in a section 38(6) exercise, there are two stages, that conclusion, then the requirement to consider other material considerations. Now, before we consider other material considerations, can I just ask, overall, looking at the development plan and the reasons that which were discussed yesterday, what is your view as to whether the development plan is up to date or not, and consequently, what weight do you give to that development plan?
So my judgment, as I set out in my evidence, is that the development plan and the policies most important for determining this application are out of date and are attached limited weight.
Thank you. And can we just spend a moment on that? I want to ask you about various factors that indicate that. The first factor is, to what extent do you say that the development plan complies or does not comply with the up-to-date guidance in the December 24 NPPF?
So a number of the development plan policies do comply, which I think I have set out in my evidence, but the policies most important to determine the application don't comply in relation to the locational policies and the spatial distribution policies.
Thank you. And let's just take that a bit further. Can we just get into another bit with the various points? The first point, of course, is in relation to let's talk about this matter, which took a bit of time yesterday, and the approach of the council in June 25, and now the way the assessment is done under the housing appraisal or the housing assessment, which is just the inspector's reference, is CDD 15. You've now seen Mr. Wood's email, and in the light of that, what do you say to the proposition that I sought to put to Mr. Callis, that it's effectively now difficult, if not impossible, to marry up spatial strategy and how it is being met in set out in the joint core strategy, because the way the council now effectively evaluates and works out the housing distribution?
As we discussed yesterday, the joint core strategy policy S3 sets out a very specific distribution of houses across what were the 3 agreed sub-areas, and the basis on which the JCS was adopted at that time. Since that time, the council have then monitored that policy and looked at their 5-year land supply on the basis of those areas. They are now not doing that and have produced a housing land supply document which sets out the figures across the whole of West Northamptonshire. There is no publication in that document of the supply for those sub-areas. So Mr. Wood's email this morning sets out how that could be calculated from the information that's available, but that information is not in the public domain and is not something that we have seen before today. So it would, as Mr. Callis acknowledged yesterday, there would be no way of working that out on the face of just looking at the housing land supply that has been published.
Well, let's go back to first principles. One can obviously get too embroiled in a case, but let's say today you got a scenario where you had two documents, the development plan and a housing assessment. And you saw that the latest housing assessment had changed the basis of calculation to a different way geographically, just that set out in the development plan. What would be your immediate reaction to that change of approach by the LPA?
If I was appraising the site today and looking at the policy in the background and the way that the council are now publishing their figures, my reaction, based on my experience, would be that the council are no longer employing that policy in the determination of applications.
Now, can I just deal with the point that was raised just by Mr. Callis? I just want your view about it. And effectively, the simple gist was that the EIP inspector went further in Paris. This is the Paris 33 to 38 of the EIP report. And what you reflected in your evidence wasn't the full story. Can you just tell the inspector what was the point that you were trying to make by referring to what the inspector had said in 2012?
Yeah, of course. The point that I used the reference or the quote from was in terms of the age of the development plan and the evidence base on which that plan was prepared and developed. I do accept that the additional work was done and the plan was adopted on the basis of an OAN that the inspector considered acceptable. Of course, since that time, that evidence base is now older again, and we now have a new standard method as introduced in the 2024 NPPF.
Now, next point on this question of, well, let's just do an order. First of all, in relation to the lack of consistency with the new NPPF, in your judgment, is that lack of consistency enough? Does it take over the threshold where judgment can be reached that it makes the plan out of date, or is the threshold not crossed, that the plan is up to date?
I think the threshold is crossed.
Secondly, in relation to the point about the calculation approach by the council that they've adopted in June 25, does that, in your judgment, cross the threshold of making the plan out of date or not?
I think it crosses the threshold.
The next point is this point about review, and you'll recall there were 2 points about, well, 3 points actually about the review. The first is the requirement in the regulation and the failure to comply with 10A, regulation 10A, and the requirement to review it. I think it's agreed on the basis that Mr. Callis, you say December 19, Mr. Callis says January 2020. I don't think that's a critical date, because it's not like we're at 4 years, 11 months, 26 days in one scenario. But firstly, is the failure to comply with regulation 10A, in your judgment, a matter which does cross the threshold whether the plan be up to date or not?
I think it's important in terms of how you then apply the tests of the NPPF.
Thank you. And in those tests, can we just take up please NPPF 34? See what is said.
Yes.
Now, what is said, first sentence, I'll just wait for everyone to get it, page 11, sir. Policies in local plans and spatial development strategies. Let's just deal with that. In your judgment, does the joint core strategy fall within the spatial development strategy or not?
Yes.
Should be reviewed to assess whether they need updating at least once every 5 years. Now, what do you say about the use of the word should? What does that indicate, please?
Well, it indicates that if it's not done, they've not reviewed their spatial development strategies or accepted that they may be out of date.
And then should then be updated as necessary. I mean, just tell us in practical terms, as a planner who operates in the world of development management on a daily basis, Mr. Buckfield, what are the consequences of non-compliance with that first sentence in 34 in your view?
If you have a spatial development strategy which has not been reviewed in the the 5-year period and is considered to be out of date for whatever reason. And I think paragraph 34 goes on to talk about the housing need, but in terms of that first sentence, if it's then not updated, then those policies should be considered out of date.
Thank you. And then we also, can we, while we're on there, we look at the gist of 232, please, page 67. We spent quite a bit of time on that yesterday, so I won't read it out again. But can I just ask you, in the light of what's said about implementation, how do you say the inspector should interpret 232 in the light of the evidential position in West Northamptonshire, please?
So I agree that policies should not be considered out of date just because of their age. I think you need to consider them against the requirements of the framework. But I think that in terms of the sort of second part of the paragraph, the local planning authority may or may not be able to demonstrate a 5-year supply of deliverable sites, and the evidence is before you, sir, on that for your decision. But the housing requirement is now greater than that set out in the adopted strategic policies. The plan is more than 5 years old, and therefore that protection, just because of the 5-year land supply, would not be applied.
Thank you. Now, also, what can I just ask you, if we go back, what do you infer from the footnote 8, for example, when questions under 11D are being reached on whether all the policies which are most important to determine the application are out of date? Footnote 8 gives the tests of the HDT, the 5-year supply, and also C power 232. What do you say the reference to 232 says about the consideration of whether a plan be out of date or not?
So the reference to 232 would then require you to consider the consistency of the policies with the framework in the first instance. It would also require you to look at the local housing need position of the local planning authority, depending on the age.
Well, let's then deal with that, please, in relation to the exceptions. And I don't know whether you have. In paragraph 18 of the opening, there is acceptance by the council. I don't know if you have a copy. Yeah, page 18, you see what's said, and it seems common ground. With respect to the increase in local housing needs since December 2024 BPF, whilst it is accepted that to reinforce that the stated numbers in the adopted development plan do now fall short of the local housing. So there is acceptance by the LPA that we have this position, that what is set out in the JCS are fall short of the local housing needs identified in effectively the December 2024 NPPF and the published standard methodology. However, what my learned friend says, that's not the relevant matter. I just want to ask you, what do you say about the relevance of the fact that the stated numbers now are stored by the government in the LHN or above, well, those above, but I think the figure is roughly 2368 against 2503, something of that nature. What do you say the consequence of that is, please, to the question of out of date or not?
I think I would refer back to paragraph 34 of the NPPF, where it says that relevant strategic policies will need updating at least once every 5 years. If they're applicable, local housing need figure has changed significantly. I think it was agreed yesterday around the table that the difference is significant. It's over 160, I think it was, in dwellings per annum. And therefore, in terms of paragraph 34, without a review of the council's development plan policies on the local housing needs and its delivery, they are failing the test of paragraph 34, meaning that that policy would be out of date because it's not consistent with the framework.
And well, I just want to see how the case goes on in para 18, because what is said, the issue is the consistency of the plan with the NPPF generally. I just want to ask your view. Is it your planning judgment and interpretation of the NPPF that the sole question in the sense of out of datedness is consistency of the plan, or are there other factors such as what the LHN is now?
in applying the tests of para 11, the requirement in terms of whether the relevant, sorry, let me just get the relevant, whether there are no relevant development plan policies or the policies which are most important for determining the application are out of date. That doesn't suggest that it's a general compliance with the NPPF. It suggests that it's a consideration of the most relevant policies.
Well, let's just have a moment on that. Let's imagine the inspector is sympathetic to the contention of the LPA's put in opening and the issues that consistency of the plan. Let's just spend a moment on that. We touched about S3. I just want to give you an opportunity to comment as you do in your proof on the point about policy SA, on the point that we evolved yesterday. It's page 24 of the joint core strategy, which for your benefit CDD03. And I just want to ask, we know, and it's common ground, that in paragraph D, 11D, there is that gateway threshold about the policies which are most important for determining the application out of date.
Yes.
And we know because effectively policy SA reflects the March 2012 version of the NPPF. The test is effectively relevant policies are out of date. I just want to ask you, as a planner involved in development management, how material is the change in national guidance from utilising the approach of judging out of date based on relevant policies as opposed to judging out of date based on the most important policies? Are they one and the same thing in your judgment or not?
No, not at all.
And why not? Why not at all?
The NPPF has evolved over the years, and as I understand, has been changed since 2012 to be very specific about the policies which can be out of date, because previously a relevant policy could be, for example, on public open space, and if that was out of date, it could trigger the presumption. And the meaning was not to do that. The meaning was still to ensure that there are protections for sensitive areas. And so the wording of para 11 was changed to be the most relevant policies for the determination of the application.
Well, let's look at this on a practical basis. An application. Let's imagine you, no doubt, when you've got a planning statement, often you might ask a colleague at work to draft a planning statement. And the planning statement comes back, and the approach taken is we're arguing the plan, effectively the plan is out of date because we're relying on policy SA because we identify effectively, let's play development plan bingo, and let's say one of the policies, let's go right to the back and look at one of the policies and say you can clearly say that one policy is out of date. R1, let's say, spatial strategy for the rural areas is out of date. In that case, can you argue under SA, the policy SA is drafted, that the relevant policies are out of date?
Yes.
Yeah. And then what do you imagine, how would that be compatible or not with the gateway threshold test in NPPF 11, which requires that to be a most important policy?
Well, in this case, I think R1 is relevant to the policy,
Yes.
but if it wasn't, then you would not, in terms of how para 11D is drafted now, you would not be saying that was the case if it wasn't a most important policy.
And the second point that I discussed with Mr. Callis yesterday was the point about the disengagement, that the disengagement, little I, specifically allows effectively the application of the policy from the framework effect areas or aspects of particular importance provides a strong reason for refusing the development proposed. Now, my learned friend in re-examination developed this argument that effectively that point is catered for on the second bullet point of SA, which is specifically what policies in the framework indicate that development should be restricted. Now, what's your view on that? Does policy SA effectively disengage the tilted balance in that way or not?
No, I think that footnote 8 is very clear about the way in which the tilted balance is disengaged and on what grounds.
Thank you. So going back to the opening, the LPA's case for reasons which is understandable from their perspective, but they are seeking to advance an argument that don't worry, sir, the plan, the JCS is up to date because it's consistent with the December 24 MPPF. In the light of our discussion about policy SA, is that a view that you agree or disagree with?
I disagree that policy SA, I think policy SA is out of date.
Secondly, we have the reference example policy S3 and Mr. Wood's note. And again, is it your judgment in the way that the council are doing these matters that there is consistency with effectively the guidance in the MPPF because the approach taken to the assessment of housing supply in West Northamptonshire now?
I think the approach taken is inconsistent.
The third point is, the reference, can we just take up your proof? Actually, not your proof, I don't know, do you have a copy of the opening speech of the appellants?
Yes.
ID 1. If you can go to paragraphs 26.5.
Yes.
Now, para 11B, as we set out there, requires in 11B, which is in the context of plan making, but it means that strategic policy should, as a minimum, provide for objectively assessed need for housing. Now, in your judgment, is that the objectively assessed needs that existed in 2012-13 or post-December 24?
Sorry, in terms of the MPPF now?
Yes.
The MPPF as the standard method was introduced in 2024.
Thank you. Next, we say that in para 15, that the MPPF requires meeting housing needs and up-to-date plans required by para 15. In a sense, does the plan that sits before this inquiry comply with that requirement or not?
No.
What about, does the plan currently make sufficient provision for homes in accordance with the December 24 standard methodology?
No, it doesn't.
And what about providing in para 23 sufficient land to address the objectively assessed need over the plan period? Is that complied with now or not?
No.
And lastly, para 8A about providing sufficient number and range of homes to meet the needs of present and future generations. Is there compatibility or inconsistency with that requirement in your judgment?
There is, yes.
So overall, putting that together, what do you say, taking just the examples of policy SA, policy S3, and the guidance relating to objectively assessed needs, in your judgment, is it your view that the plan can be said to be consistent with the December 24 MPPF or not?
No, it can't.
Now, also, can I then ask you, just formally, you heard that HLS position. Can I just ask you, in the light of the evidence you heard yesterday, do you adopt or reject the evidence of Mr. Tiley on whether there be a 5-year housing land supply in both the disaggregated areas and the aggregated areas? What's your view on that?
I agree with Mr. Tyler's evidence in its entirety on that point.
And in that stance, then, in accordance with footnote 8, is the plan up to date or out of date?
Out of date.
Thank you. Also, just a last point, can I just deal with para 317? I don't think we need to take it up, but what was said to the world back in the adoption of JCS was this commitment. I think the councils are committed to the review. Do you remember that? I just want to give you an opportunity. What do you say? Well, first of all, is it your judgment that that commitment was carried out or not carried out to carry out the review of the plan?
No, it wasn't carried out.
Does that actually matter? Where you have a joint planning unit saying we commit to carrying out the review by 2020 and nothing happens, is that effectively, well, what's your view on that, Becky?
I think it impacts both how the plan is then delivering for the future. There was obviously the reason for that review, but in the local plans part 2, they were also, and there was a number of references which I set out, Mr. Tyler's evidence as well, about how the local plan part 2 were expecting a review of the JCS.
Thank you. Right, can we then go to the last section of the examination chief and do the planning balances?
Yes.
And you heard from Mr. Callis yesterday, and I think we're in a happy position. I think you, frankly, you agree now on all the weightings. Just about the one difference is that in the light, Mr. Callis doesn't include high quality design. But I've got, these are all found in your proof at 1122, 1127 and 7.67 of the Statement of Common Ground. Well, let me just ask you this. In the light of the evidence you have from Mr. Callis, do you wish to change any of the weighting you gave to the benefits in your planning balance?
No, I don't.
Oh, and what we have, the audit, like Mr. Callis, very significant for market housing, affordable housing, significant for economic, that's in the Statement of Common Ground, limited for environmental, limited for rugby pitch, significant for open space, significant for highly sustainable location, and limited for high quality design. Can I just ask you a couple of matters that have evolved? The inspector rightly or wrongly, but I'll say rightly because it's the inspector, raised a comment about the weighting of the rugby pitches. And I just want to ask you, you give limited weight to that. And do you wish in the light of, well, in the light of, I suppose this is slightly tricky because the inspector hasn't yet seen the discussions with the LPA. So for the purpose of your evidence, I suppose you probably must keep your evidence where it is because it's unfair in the sense not to review this in the absence of seeing where the 106 is. But just can you just confirm that there are discussions ongoing with the LPA for how we can meet the concern about what would happen if the rugby club effectively used to take on the land?
Yes, I understand those discussions are ongoing.
Next point, can I just raise high quality design? Mr. Callis was in the unit, shouldn't form part of his balance because effectively this is an outline application. I just want to get, you have included it, albeit given it limited weight. Can you just tell the inspector why you reached the judgment it was a valid matter to be in the planning balance?
I think it's a valid matter to be in the planning balance in terms of the master plan of the site that has informed how we have progressed and, well, how the site was progressed and developed to the application proposals that were in front of the inspector at this appeal in terms of how they've shown how the site can be developed, the quantum of development that can be delivered on there.
Thank you. Now, overall then, can I just ask you, Mr. Callis, we'll recall yesterday, I asked him cumulatively weigh and he gave the issue as substantial. Is that a judgment you agree or disagree with, please? When you cumulatively add up your 8 planning benefits, what weighting do you give to them?
Yeah, well, I would say significant or very significant rather than substantial, but I would disagree with Mr. Callis's overall view.
Thank you. Now, let's then please do the impacts. And you set out your evidence 3 impacts. Breach to the spatial strategy, limited. Landscape visual harm, limited. And noise during construction, limited. Is on the basis of the evidence that you've heard, and upon reflection, it's now 5 weeks almost since, well, 4 and a bit weeks since you did your proof of evidence. Do you wish to review or amend those weightings like the evidence?
No.
What about in the sense of we had from the rule, well, not rule 6, we had from local, we had the councillor and the anglers, their concerns. You've obviously had the benefit of reading the bridge response. Is it your judgment that their concerns about the effects of the development on flooding and drainage are matters that weigh as an impact on the planning balance or not?
No, I don't.
So overall, then, taking into account your impact, what weight do you give cumulatively to the impacts you've identified in your evidence, please?
The adverse impacts.
Yes, the adverse.
Yeah, limited.
Limited. So, applying the tilted balance, which I assume, applying the tilted balance as a starting point, weighing. Let's just go, this is absolutely clear in the MPPF power 11. Let's be absolutely clear about it. We're in effectively D2 territory.
Yes.
And it's just worth noting, if the inspector of D takes the view that the most important policy is out of date, granting permission unless, the starting point, granting permission unless any adverse impacts of doing so would significantly and demonstrably outweigh the benefits. Now let's insert your weighting. So you put limited, any adverse impacts which you weigh as limited would significantly and demonstrably outweigh the benefits which you weigh as significant, very significant. And in your judgment, therefore, what is the outcome of your application of the tilted balance?
the tilted balance would suggest that planning permission should be granted.
Then let's move on to the callous scenario where actually the inspector should come to the conclusion the development plan is up to date. There are no reasons for concluding it's out of date and the tilted balance is not engaged in this matter and we have a flat balance. Balancing significant and very significant benefits against limited impacts, in your judgment, reaches what conclusion on the flat balance?
That planning permission should be granted.
And can I just deal with the final question I want to ask you? Based on your joint instruction from the three applicants, what is your view as to whether, if the inspector was minded to grant planning permission on their evidence, whether the application could be implemented or not? Is it within the ability of the applicants, as far as you know, to actually develop this development and bring forward the benefits or not?
Yes.
Thank you, sir. That's my examination in chief. Thank you.
Thank you very much. Mr. White. Mr. Fraser, could you commence unless you want to break?
Have a 5-minute.
Yep.
I think looking at my notes, that we will probably be able to get through the entirety of the cross-examination.
Okay, in which case, can I just remind the witness your obligations in terms of not speaking to anyone? So if you need to use facilities, you need to ensure that you do that without speaking to anyone or being influenced by anyone. I'm sure you recognise your professional obligation in that respect. All right, it's 10:26. If we take a 10-minute break and resume at 10:35, a short 2 minutes. So we'll adjourn at that particular point back in this room at 10:35. Thank you.
Yeah, okay, thanks. Yeah. So let's switch the audio back. So go to the up arrow next to audio. Yeah. So let's switch it to right on top of Microsoft microphone. Two, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2. Sorry. 3, 4, 5, 6, 7, 8, 9, 10. One, two, 1, 2, 1, 2, 1, 2, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Right. Here we go. 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2. I'll do it for about a minute. 1, 2, 1, 2, 1, 2, 1, 2, 1, 2, 1, 2. Mary had a little lamb. Blah 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 blah. 2, 1, 2, 1, 2, 1, 2, 1, 2.
Right. It's 10:35. The inquiry is now resumed. We're going to go straight into cross-examination of the planning witness. Mr. Urquhart. Fraser Urquhart. I nearly got it right. We had a chat about the pronunciation of Mr. Fraser Urquhart's name over the break. And I nearly got it right, except I missed the first part out, so.
No, you didn't. You got it horribly wrong, if I may say so.
Oh, right,
It's not Urquhart. There's no Q involved, although it's in there. It's Urquhart.
Urquhart,
Urquhart. Yeah. An Englishman's pronunciation is Urquhart.
Urquhart.
Yeah.
Mr.
Scotsman.
Fraser Urquhart.
Scotsman says Urquhart, but there we are.
I'm going to make a note of that, actually, Mr. Urquhart,
Yes.
because it would, no doubt we'll be seeing you again.
I hope so. And that is the Urquhart tongue. So just so we're clear about these matters. Now, national identity is established, at least in my case. Miss Butterfield, and can I apologise in advance? I have a very good friend who's called Butterworth. So if I default to calling you Butterworth, that's why, and I apologise.
It won't be the first time.
I'm sure.
Probably won't be the last
Sure
time.
it won't. No, we all have these issues. For the purposes of these questions in cross-examination, you're going to need the following documents available: your own proof
Yep.
and rebuttal, Mr. Callis's proof, none of these are surprising, the NPPF, the report to committee, joint course strategy, the appellant's opening, and two perhaps that we've not looked at before, CD D18, which is the Reg 18 document which was published but which is not being now proceeded with, and HO7, which was a press document which I'll come to.
Right, sorry, I got to the committee report and I might have missed a few after that.
Joint
I'm
course
just trying to
strategy,
open them. Joint course strategy, yeah.
yeah, appellant's opening.
Yeah.
And then D18, CD D18
D18.
and CD H07.
Sorry, so D18 I've got as the Housing Land Availability Report, April 25.
Oh dear,
That wrong.
sorry, I can't read. CD D14, my apologies.
D14.
Yeah.
I'll just find Mr. Callis's proof. Okay.
Okay, let's, I'm afraid I'm going to ask you a question which you've been asked about 3 times already, but I just want to have it in my sequence of evidence. You accept, as I understand it, that even on the basis of a flat planning balance, planning permission should be granted.
I do.
And that means, on the basis that there is breach of the development plan, that there are material considerations which are capable of outweighing the breach of the development plan,
Yes,
even on a flat planning balance
even on a flat plan balance.
where the development plan has full force.
If that's what the inspector decided, yes.
Yeah. Thank you. And the dispute between us, to put it accurately, is whether or not the planning balance should be concluded on a flat or a tilted basis. That's the nature of the dispute, isn't it?
Yes,
Thank you. And just so that we are clear, it's right, isn't it, that if the inspector comes to the conclusion that there is not a 5-year supply, effectively that's game over for our case and the tilted balance would apply.
yes, I agree.
And therefore, can I just say that all of the questions I'm going to ask of you are on the basis that there is a 5-year supply. I appreciate that's not your case, but that's the basis upon which I put the questions. Okay?
Okay.
Thank you. Now, before we look at the tilted balance questions in detail, can we just take in hand, please, the NPPF? Paragraph 7, please. And recognise from paragraph 7 that the purpose, sorry, you there?
I'm there. Thank you.
The purpose of the planning system is to contribute to the achievement of sustainable development.
Yes, I agree.
And that's reflected in the mutually supportive three objectives which are set out in paragraph 8.
Yes.
And at paragraph 10, it's suggested that the purpose of the presumption, which is set out in paragraph 11, to which we'll come, is to ensure that sustainable development is pursued in a positive way.
Yes.
Thank you. Now, let's have a look at paragraph 11. Turn that up, obviously. And I'm just trying to identify the routes to getting to the tilted balance, because that, as you've agreed, is the issue between us. And we don't need to worry about the plan-making bit. For decision-taking, approving development proposals that accord with an up-to-date development plan, well, we don't need to worry about that for the purposes of these questions. The way we get to a tilted balance is set out in D. In the following terms, isn't it? First of all, no relevant development plan policies. Agree between us, that's not relevant, is it?
Agreed.
And therefore, the only other route set out by paragraph 11D is where the policies which are most important for determining the application are out of date.
Yes, agreed.
Yes. Now, obviously, we use a shorthand. We're all guilty of it, of talking about the development plan being out of date. But for the purposes of this dispute between the parties, the issue is whether the policies which are most important for determining the application are out of date. That's right, isn't it?
Yes.
Now, before we go on to look at the different routes that we've argued, can we just take a moment to consider policy SA, please, from the joint course strategy? You can turn it up if you want to, but it's not strictly necessary. Can you take in hand, first of all, please, the report to committee, which is CD CD08, C08. Now, it's right, isn't it, that in your examination in chief, and indeed the cross-examination of Mr. Callis yesterday, you were asked to draw a distinction between relevant policies and the policies which are most important. And you said that that was an important distinction. Thank you. Can we look, please, at the report to committee at paragraph 7.10 and following? I'm afraid it's not paginated, so you'll just have to use the
No, it's fine.
paragraph numbers.
I'm there very quickly. There, yep.
Yes, I'm there.
Now, one would expect, wouldn't you, that when considering, as this section does, the principle of development, the policies of the development plan, that the officer's report would identify those policies which the officer at least thought were most important for determining the application.
Yes.
Can you identify within the paragraphs that follow anywhere that that policy SA of the joint core strategy is referred to?
But how far do you want me to,
Well,
read down?
Well,
If you want me to.
I'm going to suggest to you, I'm
Between
going to,
paragraph 710 and 714, I don't believe that Mr. Callis refers to policies.
yeah, okay. Thank you. Now, if we could take in hand in this slide, please, also Mr. Callis's proof. and turn within it to page 9, please. Tell me when you're there.
Yes.
Thank you. You'll see here that at paragraph 7.5, Mr. Callis refers to the relevant policies of the joint core strategy, and he identifies policy SA as a relevant policy. Then at 7.6, he considers what he calls the key policies. Now, it's fair to read key as meaning most important, isn't it?
I think that's I would take that as read as that's what he meant.
Yes, good. And it's right again, isn't it, that in the key or most important policies, Mr. Callis doesn't anywhere in there identify reliance on policy SA.
He doesn't know.
Can we take in hand now, please? This terrible phrase, the horse's mouth, has been used too often in this inquiry, but can we take in hand your proof of evidence, please? And turn within it to page 17. But no, let's not waste time wading through that, although you can if you want to. Let's go to 640 on page 27. And we see there a table you call Summary of Development Plan Policy Compliance.
Yes.
And it's fair to say, obviously, that these are, as you're specifically drawing attention to compliance or otherwise with them, the policies that you consider to be the most important for determining the application.
I think it's policies that are in the development plan that I've set out. I don't think I specifically say they're most important. I think I've looked at the development plan in terms of compliance with the policies within it.
All right. But it's right, isn't it, that in that summary, you don't anywhere refer to policy SA?
No, I don't. That's correct.
So it's a fair observation to make that neither in the report to committee, nor Mr. Callis's evidence, nor your evidence, has policy SA been identified as one of the policies which is most important for determining the application.
Excuse me. No, neither I have not identified it in that way, no.
Now, I want now to turn to your comments on the status of the development plan. 641 in your proof, please, page 28. You consider there various matters which you say at 641 mean that the plans should be considered out of date. Now, it's right, isn't it, that when we read through these matters, we have to bear in mind the evidence that you've already given, which is that what we're actually looking for is the policies which are most important for determining the application. All of this has got to be read in that light, hasn't it?
Yes.
Let's look in turn at the various factors you do identify and relate them to policies. Just one matter before we get into that. The first issue is the age of the plan that you identify. And this has been a very good-tempered inquiry, so I'm almost loath to ask this question. But you accept, don't you, that the quote you gave at 644 from the inspector's report, which we discussed yesterday and you referred to it again in evidence in chief, was not a complete recognition of the position adopted by the planning inspector on the examination of the joint core strategy, was it?
Yeah, I think I accept that my points on that were slightly clumsy and in the manner that they read were not necessarily the manner intended, as I explained in my evidence in chief.
Yeah, okay. Well, you've accepted clumsy, and I'm not going to press you beyond that. We'll take that as a recognition. Is it your suggestion that the age of the plan alone is sufficient to render it out of date?
No, not on its own.
Right. What other factor do you say is necessary to render it out of date? Because you have said age of plan, haven't you?
Yes, and obviously there is a requirement for a plan to undertake a regulation 10A review, and paragraph 34 of the NPPF repeats that, but it also suggests at paragraph 34 that in undertaking that review every 5 years, those relevant strategic policies need updating if the applicable local housing need figure has changed significantly, and this plan is of an age where that housing figure has now changed significantly.
Do you know when the requirement to review came into the NPPF? Was it in the first version of the NPPF?
Off the top of my head, I'm sorry, I don't know.
It suggests that it has always been in there. And the regulations relating to the need for a review are date from 2012, don't they?
Yes.
Yes. I appreciate you're not a lawyer, but you are a planner. Do you appreciate that there's been case law since the existence of the requirement to review, which identifies that age alone is not a basis considering a plan out of date?
I accept that. I don't think that's my point, that this on its own is enough to render the plan out of
But
date.
each of those cases which considered the argument that age was sufficient to render a plan out of date will also have been undertaken in a context where there was an obligation to review, won't they?
I would just assume so. I'm looking at the cases that you're referring to.
Fair enough, but I can make submissions. Thank you. Now, the next point that you make in general terms is that the move to calculation of housing land supply on a West Northamptonshire wide basis, represents, therefore, by definition, you say, an abandonment of the spatial strategy. That's the point you make, isn't it?
That's what I've written, yes.
Obviously, you don't point, do you, to any document or resolution or anything of that nature which says that the council has that intention?
No.
You say it's a natural consequence. Just focusing in on the policies, can we consider first of all policy S1 of the joint course strategy? This sets out, doesn't it, effectively the hierarchy by which development will be distributed in the West Northamptonshire district as a whole.
It does, yes.
Take in hand, would you please, your own proof of evidence. Go to paragraph 7.6. Which you find on page 36. Tell me when you're there.
Yeah.
And you accept that the spatial hierarchy remains relevant and appropriate as it directs development towards a number of sustainable locations, including Brackley, across the plan area.
I do, yes.
Yeah, just going to pause there. I know you go on to make a qualification. And that basic hierarchy remains suitable and appropriate for governing the distribution even of a higher number of housing units than is provided for the plan, doesn't it?
Well, it could do, it's not been tested against
But
a
on your
higher
own,
number
on
of
your own
units.
assertion,
It remains, I think it remains relevant in terms of directing development to sustainable locations, yes.
and as we considered earlier, that's the fundamental purpose of the NPPF, to secure sustainable
Yes.
development. Now, you make a qualification relating to Brackley, and you suggest it perhaps should come higher up the hierarchy now, thus rendering the hierarchy out of date. Just look at policy S1 for me for a moment, would you?
Yes.
It's right, isn't it, that the hierarchy provides for meeting the development needs of, omitting a few words, Brackley.
Yes.
And the thing that you particularly point to in justifying or suggesting that the focus on Northampton and Daventry is out of date and the policy should attach limited is the expansion of the Mercedes headquarters. That's what you say at paragraph 7.7, isn't it?
I've referred to that, yes.
Yeah, you've referred to it. That's what you say is the basis of a significant factor which should be reflected in the council's spatial strategy. That's what you say, isn't it?
Yes, I think it links into the comments that I've made about the age of the plan and its evidence base, and that matters have now moved on, which may influence the spatial strategy.
Thank you. Let's just put a little bit of flesh on the bones of what you say. Do you know when Mercedes established their headquarters in Brackley?
Not exactly, no. I know they've been there quite a long time.
Yeah, donkeys. Before the joint core strategy, wasn't it? Yeah. Thank you. Can you turn up, please, so that we have a sense of the scale of all this? Core document H07.
I'm not sure, sorry, I just need to, I don't see 807 at the minute.
H.
H07,
Yeah.
sorry.
Hotel Oscar 7.
Sorry, yes, I'm there, sorry.
Thank you. Good. This is a press release or press article, not entirely sure. And it indicates, doesn't it, that the actual scale of the expansion is from 1400 to 1900.
Sorry, it refers to, 500
Yeah.
jobs, yes?
Well, read the paragraph that says Mercedes has
Sorry, yeah,
plans.
I'm there now, yes,
You're there,
page
got
2,
it.
yeah.
1400 to 1900. So that's the scale of the expansion, yes?
Mhm.
And can we also now please have a look at CD 14? sorry, CDD 14.
The regulation 18.
That's the
local
one.
plan.
I'm going to have to find this myself, so. Tell me when you're there.
I'm sorry, yes, I'm there.
Sorry.
Sorry.
Yeah, you're ahead of me in this case. And can you go, please, within that document to paragraph 7.2.9? Yeah.
Yes.
And it's right, isn't it, that that identifies, makes note of the very expansion of the Mercedes headquarters with 500 new jobs to which you refer in your proof.
It does, yes.
And if you could then please go to policy S1.
Yes.
And I will accept whatever caveats you want to put about the weight to be given and all of that. But it is right to note, isn't it, that this council, when bringing forward its regulation 18, knowing full well about the Mercedes expansion upon which you rely, did not alter the position of Brackley within the spatial tiered hierarchy.
No, but I believe that that regulation 18 was also undertaken before the December 2024 MPPF.
Indeed it was. Thank you. And in the light of all of those factors, do you still maintain that the expansion of Mercedes is sufficient to overturn the tiered hierarchy, which is at the heart of policy S1?
I would maintain that's a factor to be taken into consideration in the preparation of any new plan.
Thank you. Bet we'll have heard that question and that answer. Now, next issue is this. And this is, I have to say something I just struggle to understand. You've accepted that policy S1 is capable of directing development to sustainable locations with a tiered hierarchy. The change to the way in which the 5-year housing land supply is calculated from the 3 component authorities to a district-wide calculation. That is simply a mechanism of how housing land supply is calculated, isn't it?
I think the intention of the policy is how that land supply is delivered across those sub-areas that were agreed as part of the joint core strategy.
That's not an answer to my question. The calculation of housing land supply is simply a matter of how you calculate the numbers, isn't it?
On its prima facie, yes.
It doesn't detract in any way from the ability of policy S1 to continue to direct development in a sustainable manner, does it?
No, but the council's monitoring of how and where they are delivering and the change in the nature of how they're doing that means there is less recourse to essentially where that development is being delivered and therefore where it is needed to meet the requirements of other policies in the core strategy.
I note your first answer, thank you. Now, another matter upon which you place weight is the situation concerning policy S3. And paragraph 7.10 of your proof, you draw attention, don't you, to the fact that the local housing need is now substantially higher than the adopted figure in the policy S3.
Yes,
And that's your basis for saying that the policy is out of date.
yes.
Thank you. You take in hand the MPPF, please. Go to paragraph 232. Tell me when you're there.
Yes.
Now, this paragraph considers the situation where a local housing need is greater than the housing requirements set out in adopted strategic policies, doesn't it?
Yes.
Now, I will come back to the 5 years point, but it's right, isn't it, that this policy, this paragraph expressly contemplates a situation where policies which set out a housing requirement which is less than the local housing need figure calculated by the standard method explicitly contemplates that those policies are capable of being not out of date, doesn't it?
Yes, for a specific period.
For a specific period. So the mere fact of being out of date, sorry, of being, start the question again. The mere fact that the local housing need is higher than the housing requirements set out in adopted strategic policies is not of itself a reason for those policies to be out of date, is it?
Well, in this case, I would suggest it is because the plan is more than 5
Because
years
of the 5 years.
post-adoption.
Yeah, well, we'll come back to that. Thank you. Now, just looking at S3, again, please, if we may, and you'll also want to have to hand the report to committee for this next couple of questions.
Okay.
Policy S3 sets out scale and distribution of housing development. And normally the way a local plan works is that it will seek to allocate sites to meet that housing requirement, doesn't it?
Yes.
And obviously there's a small allowance for windfalls and so forth, but the primary mechanism is to allocate sites to meet that need. This site isn't an allocated site, is it?
It's not, no.
No. And just taking in hand, if you would, the committee report, please, paragraphs 710 and 711.
Yes.
Policy 711 identifies that 80% of the housing need within S3 is to come through strategic allocations,
Yes.
and the rest is to come from windfalls within the confines of Brackley.
Yes.
This site is not within the confines of
It's
Brackley,
not, no.
as the report, the next paragraph goes on to write. this policy S3 isn't directly relevant to the determination of this application, is it?
Insofar as where the site is located.
And policy R1, which is relevant, because it's the rural areas policy, that policy is breached, but as you've already accepted, it is capable of being outweighed by other material considerations.
Yeah, sorry, your previous question about policy S3, the spatial distribution does refer to South and Northants rural areas, which would be what this site falls within.
In any event, the key location of policy R1 is capable of being outweighed by other material considerations, and it is in this case, isn't it?
Yes.
And one of those material considerations is the need for market and affordable housing, isn't it?
Yes.
And that's a factor to which you attach significant
Yes.
weight. Now, I think just final set of points on paragraph 232. I promised you I'd come back to that. Do my best. Before we dive into 232 itself, let's just look again, if we could, at para 11 of footnote 8, please.
Mm-hmm. Yes.
Now, footnote 8 sets out, as a matter of language, two situations where you definitely have out-of-date policies, which is where you haven't got a 5-year supply, or where the housing delivery test is less than 75%.
Yes.
Yeah. And the language makes absolutely clear that those are situations where automatically the most important policies are out of date. Yes?
Yes.
That language is not used about para 232. It just says see also paragraph 232, doesn't it?
Yes.
And then if you look at 232 itself, it does not say that if the plan is over 5 years since the date of adoption or review, that the policies become out of date, does it?
No, it doesn't. It requires you to look at them in accordance with the
It just-
consistency with the framework.
It tells you one circumstance where the policies are in date, doesn't it?
For a period of time, yes.
Yeah, no, it tells you that the policies are in date in certain circumstances, and it says that is for 5 years. That's one set of circumstances. It doesn't say the opposite, does it? It doesn't say that in other circumstances the policies are automatically out of date, does it?
It doesn't specifically say that, no, but I don't know why it would agree. It would include a period of 5 years if after that there was not an implication arising.
Thank you very much. Just give me one moment, would you please? Yes, Ms. Butterfield, thank you very much. Those are my questions for you. Thank you, sir.
Thank you very much, Fraser Urquhart. Re-examination.
Just on one point, please. Ms. Butterfield, I want to go back to the question about policy SA is the most important policy. What you accepted in re-examination, you accepted my learned friend said you had not identified in your proof that it was the most important policy.
Right.
Now, I want to ask you this. do you remember my learned friend also put to you in his early introductions of cross-examination, the purpose of the planning system is to achieve sustainable development, and you agreed with that, do you
Yes.
recall?
Yes.
And I just want to ask you, could you please take up SA policy, and could you tell the inquiry what in your judgment its purpose is, frankly?
Well, its purpose, I mean, it reiterates the presumption in favour of sustainable development as was in place at that time, but therefore is clearly to help the plan to deliver sustainable development.
Thank you. And if the primary purpose of the planning system is to achieve sustainable development, how important in your judgment is policy SA to achieve that aim?
I think it would be an automatic consideration.
Thank you. Next point, could you just take up the planning officer's report, please, which is CD 08A. It's found in 3 places, actually.
Yes, I think I have GO1 as well. Yeah.
Yeah,
Yes.
exactly. Wherever you've got it, take your pick.
Yes.
And could I just ask you to take up paragraph 910?
Sorry, I'm just scrolling through. Thank you. Sorry, so 910.
Yes. It should be a sentence beginning or paragraph beginning Brackley. You see?
I'm sorry, it's just reverted back to the page I was on. Bear with me, sorry. Yes, I'm there, sorry.
Could you please go to the second sentence, starting notwithstanding the identified conflicts with parts of the development plan?
Yes.
The proposal generally accords with the definition of sustainable development as set out in the MPPF and JCS policy SA.
Yes.
So how does the officer judge what the definition of sustainable development is by reference to the development plan?
He refers to his policy SA.
Yeah, and therefore, let me ask you, in the light of that, what is your view? Let me express this, what is your view in your judgment when what the inspector's considering paragraph 11, in your planning judgment, is it a most important policy or not?
It has to be an important policy in the context of paragraph 11, which is and the delivery of sustainable development.
Thank you. Thank you, sir. That is my re-examination. That concludes the case of the appellant at this inquiry.
Thank you very much. Just bear me 1 second.
Oh, yes,
Mr. White.
sorry, yes.
No, you're okay.
I'm not trying to, I'm not trying to cut you off.
Thank you. Thank you, Mr. White. Right. As far as the inquiry programming goes, that concludes the formal evidence from witnesses appearing at this inquiry. So at that particular point, other than the closing submissions tomorrow, there'll be no further oral submissions from witnesses unless there are something that we require before we commence those closings tomorrow. Not in the terms of the formal appearance, but it might be clarification, some additional ID documents that might have arisen overnight or in the morning that we might just need to ask Mr. Wood, Ms. Butterfield or Mr. Callis about the nature of certain things. But as far as presentation of evidence goes, that's the final part of this inquiry's formal evidence. That leaves us on to just a couple of housekeeping matters, I think now. It's 11:20. And I'm very conscious about people having time for a lunch or a break before we commence a site visit. So I'm looking at Ms. Butterfield and Mr. Callis here in terms of the site visit itself. We've talked about now going in one vehicle. Would 12:30 be an appropriate time to leave here? Or would you like a little bit longer? I'm just conscious of light as well.
That's fine with me, sir.
Yeah, fine with me as well, sir.
So if we to say that we'll depart for the site visit from here at 12:30, that will take us on site probably just before 1 o'clock-ish or thereabouts at the first meeting point. So I'll be outside front doors and whoever it is who's driving, whoever's not driving will be outside the front doors at 12:30, and we'll depart from there. The route of the site visit's on the inquiry website. So if anybody's listening online who is anticipating attending that, it sounds like we're going to be there around about 1 o'clock-ish in terms of getting out of the cars, sorting out to commence that. And I understand arrangements are in place to meet anyone from the angling club in the visit to the lake. I think that's all we need to say about the site visit. If anybody's listening online, I repeat what I said at the opening of the inquiry, that its purpose is for me to view the site, for people to point out features, but it's not for any presentation of any case, to make further submissions on anything that you might have heard. It's purely a site visit for me to see things, and I may ask for things to be pointed out, and I may ask people to point things out, but I'm sure the witnesses understand that. I'm saying that mainly for people who might be listening online. Right, in terms of housekeeping then, we expecting the document from Mr. Wood today.
So that is with pins, and it's with Miss Butterfield. Obviously, she won't have a chance to pick that up. She's been giving evidence, but it's in her inbox, and it's with Tim Salter at pins. So
Yep, that came through at 10:43.
Yeah, I've received it.
So, then 1 second. That document, which I'm just looking at the title without open, it says the WNC 5-year housing supply SOG signatories. I'm going to call that inquiry document ID 13. That's an unlucky name to give that one. Just bear 1 second. Before we commence closing submissions in the morning, Mr. White, Mr. Urquhart, Fraser Urquhart, well, I'll just ask if there's any comment that you want to make on that document, or whether or not there's any submissions that you intend to make on that document, because none of us have seen it in any detail.
Well, what I will do, sir, I think to be fair to my learned friend, I will try and ask, Mr. Tiley is normally pretty efficient. Miss Butterfield will send it to Mr. Tiley right now. And what I'll undertake to do is ask him if he get any comments.
Yep.
Will be received by PIN's close of play tonight. So my
That's
learned friend's
helpful.
got time to consider it
That's
before he
helpful.
closes. I mean, that,
That's kind, I appreciate that.
yeah, I doubt there'll be much, but it'll probably be a reiteration of what was said yesterday morning. But I understand the need. We obviously don't want to delay anything tomorrow morning.
No problem, but I will just touch upon if there's anything on that tomorrow morning
Yeah.
we need to deal with. Then I think that is the remaining outstanding matter beyond what we've already talked about, the conditions and the section 106. I'll go through again tomorrow when we've completed the closings on timescales on those again, just to reinforce that. I'm not going to go through it again now, but it's effectively 2 weeks for the track changes, sorry, 1 week for the track changes, 2 weeks for thereabouts for the conditions and the final version. Don't think I need to say anything more on that. Unless there's anything else in housekeeping other than a reminder to pass us back to the council officers, I don't think I've got anything else that I need to think about, or I do need to think about something, just a reminder about the Zoom call invites, which I don't think we've received yet.
Mm.
That will set us back considerably if we don't get those.
Sorry.
Yeah, thanks, sir. I believe that they are in progress. I think colleagues were circulating those this morning. I think it has possibly already gone to Tim at Pins, and we were looking to obtain Mr. White's email address. But that is in hand and it will be circulated.
Would it be helpful if I send you all of our team's emails so it can be copied to them?
Yes, although, sir, I think you said the event was just for yourself and the advocates
No,
tomorrow morning.
in terms of participation, it is, but the
Right.
event's live streamed anyway.
Yep.
So I'm not going to permit, other than people who might be responding to the document that we've just talked about earlier, the note from Mr. Wood, and anything that would be an update to the 106 or conditions that Mr. White could deal with anyway. I'm not anticipating anybody else having to speak.
No, sorry, I meant for the purposes of everyone being able to watch.
Well,
Just
they
need to-
certainly can, but it's live streamed anyway. That the whole reason why we're doing Zoom
Right,
is
okay,
because it's
Fine,
live streamed,
apologies.
so everybody can watch it anyway. So
Sorry, I forgot it was Zoom rather than.
I would
Teams.
expect somewhere in the background, if I'm being honest, that yourself and Mr. Callis would be, and probably Mr. would be available if we need to pick anything up from that note that's just been sent out by Mr. Wood before we commence closings. Once we commence closings, that's it really. There will be discussion about costs, which I'm sure Mr. White and Mr. Fraser will deal with, but I'm not anticipating anybody else participating tomorrow, if I'm being quite honest.
Yeah, apologies, it was me
No,
and
I
Teams and
understand.
Zoom.
You don't worry about it, I understand. But I think it's probably important that you three are somewhere in the background, because there might be something arises from that note that we just might need a little bit of an input before we start the closings. But once the closings start, there's no interruptions, not from me or anything. I just do the button handing. Then up to the discussion on costs, then I will do that final bit of housekeeping, and just that final reminder. I will say I'll be sending an email out just to confirm that, and then I will eventually close the inquiry in writing once I've received the completed section 106, and that will be it. Is there anything else in housekeeping that we may need to think about that we've not thought about? Mr. White,
No, thank you, sir.
Mr. Fraser,
Nothing from me other than to thank you for the way in which you've conducted the entire inquiry timetable and for the courteous manner in which this inquiry has been conducted.
yeah, that applies to everybody, including the people who participated on Tuesday. Thank you for that. I appreciate that. Thank you for, it's a different inquiry to what we normally experience. But nonetheless, we've dealt with it in a manner that required the due respect to the inquiry procedures. So thank you for that. Thank you for organising everything the council's done, because it's no mean feat to organise this room for 4 days and organise the inquiry passes and everything else that goes with it, and keeping everybody happy in terms of technology and facilities management, staff and rooms and everything else. So thank you for that. I appreciate the effort the council's put into organise this inquiry. If there's nothing else, no burning other issues, I think all that remains for me to say is thank you to everybody who's participated. We're going to break now for lunch. The inquiry is not formally closed. It's adjourned now to the site visit. So we will see everyone who's attending that site visit outside the main entrance, in terms of the people who's going in the car, 12:30 to be on site round about 1 o'clock. Okay, and I think it's probably boots because it rained quite a lot yesterday. In which case it's 11:28. We'll adjourn at that particular point and recommence on site at, or recommence outside of it for the transport to site for 1 o'clock. Thank you.